All right. Hello, everyone. This is Ollie Ellinger, the Managing Attorney of Legal Services of Northern California, Solano County office. So I'm following up on our Lunch and Learn Elder Justice session from yesterday. And we were talking about eviction and in the age of COVID-19 and how that might affect the elderly individuals on either side of an eviction that come into your office, those of you who support elderly folks. We had plenty of fantastic questions during the Q&A session yesterday, so I'm glad I finished 3 minutes early so we could squeeze in a few more while you were on. But we wanted to run through the rest of the questions that you folks had. Before I dive into those, I had a nice follow-up conversation after the session with Victoria Snyder, an attorney from Contra Costa Senior Legal Services. She's a fantastic attorney and a great friend, and she wanted me to clarify a few things we said about using restraining orders to remove, unwanted folks from a residence, right? So, for instance, an elderly couple has a family member move in and they can't get them to leave, and right now evictions are difficult or moving a little more slowly to prevent homelessness in COVID, and by and large, I think that's a good thing. It helps keep folks off the street, keep folks housed in a time when their health might be in danger. But there's always two sides to everything, and it also, some of these instances might be keeping folks in situations with people who might be dangerous to them. And so I had mentioned that civil harassment restraining orders and elder abuse restraining orders can be used to remove people from a rented residence. And Victoria brought up a few clarifying points that I definitely wanted to make because she's absolutely correct here and definitely an expert on this. And one is that an elder abuse restraining order can't just be used to get rid of someone who's overstayed their welcome. There's got to be an element of elder abuse, which is usually a physical violence or the threat of violence. But sometimes it can be sort of the act of keeping an elderly or dependent adult from support that they need, my financial support, maybe access to a kitchen, food, things of that nature. But it can't just be this person's here and I want them gone. Victoria correctly pointed out to me that I had indicated a civil harassment restraining order can be used when someone is not elderly or a dependent adult, and that is incorrect. A civil harassment restraining order might allow a court to keep parties apart and keep parties from contacting, but it can't be used to move somebody out of the property. A domestic violence restraining order would have to be used, and in that case, there'd have to be domestic violence, which involves, a stalking, threats of violence, or a pattern of violence among folks that have a qualifying relationship, an intimate partnership or a family relationship. And these situations aren't supposed to be a way to get out of a contractual agreement that someone entered into a tenancy. They're a way to protect people from violence and abuse. And so, to the extent that I might have made that sound like a loophole or a backdoor way to do that, I do apologize. I wanted to make folks clear about their rights and their abilities here. And so a million thanks to Victoria for chatting with me about that. And so with that clarification, let's jump into the questions that folks had that we didn't get to. And so I'll read them out and sort of answer them as best we can. One thing I'm going to point out is that I can't give specific legal advice to folks. So to the extent that you might be asking a question that's very specific and you probably have one person in mind, I won't be able to give a direct answer to that, but I can just sort of point to the general concepts in the law and the general rules that this situation might fall under. So I apologize for that. That's a very lawyerly answer. So, I guess that I am a lawyer for real. I'm not just making it up, if I can give you that mealy-mouthed answer there. So the first question we have is, if you are allowing a friend or a relative to live in a house you own, but they do not pay rent, are they still considered a renter? And is the process the same to get them out if they refuse to leave? So we had a lot of questions about that. When does somebody cross the line from being an occupant to being a renter? Because these protections I spoke about, or this process I spoke about yesterday, the termination and eviction or termination and unlawful detainer process, those only apply to tenants, folks who enter into a landlord-tenant relationship, which does not have to be in a written rental agreement, and it doesn't have to involve the exchange of monthly rent. It can involve the exchange of something else in value, as long as there's a a contractual relationship. And so, I mean, these are very gray areas, right? And so this specific question is asking if a friend or relative is living in the house you own, but they're not paying rent. If it is a minor, if they're staying for if it is sort of a short-term arrangement, and these folks are staying in a home that somebody owns for a short amount of time, the law considers them guests, and they should, and you, if they overstay that welcome as a guest, you might be able to remove them as a trespasser, which would involve just calling the police. Our experience with the police departments in Solano County during the pandemic is that when there appears to be a dispute where one party is trying to remove another party from a home, they seem to be stepping back and saying this might be a matter for the courts. But if you have someone who's only staying there 2 or 3 days and they're not leaving, that person is more likely to be a guest. You have someone staying 4 or 5 years with you, and maybe they don't pay you rent, but you've let them stay 4 or 5 years. I think it's reasonable to assume that person has some sort of expectation they can continue to stay there, and that person might be considered a tenant. And the term for that is a tenant at will or tenant at sufferance, which is someone who you allow to stay but in a place you own by your consent, whether or not there's rent. And so the best answer to this question is it depends on a lot of the circumstances, including whether there's an exchange of services or money for someone to come in there, to come in and live in the place, and how long it's gone on for. So there you go, another it depends type answer. The next question is, to be a renter, does there need to be a signed lease or rental agreement, either month to month or longer, or does a verbal agreement still require the same process for eviction? And that's a clearer answer, and the answer is yes. A verbal or oral contract is a valid contract to rent, and all that's required is the exchange to happen, someone to have the right to occupy and stay in a property for some sort of exchange. Come over, yeah, come live with me, pay me $500 to stay in the room in my house. That's an oral tenancy. So it does not need to be a signed lease or rental agreement. It does not need to have a specific fixed term. It doesn't need to have the 38 pages of 2-point font that many of us are used to signing when we're in the rental market. As long as there's that exchange, the right to stay in the property for something of value. So the next question is, what are the legal rights of a family who hired a caretaker or caregiver for their father? In lieu of money, they included room or board for that caretaker. When the father passes and the family wants the caretaker to leave and the caretaker refuses. So in sort of, there are several layers to this question here, layers to the rights involved. The first is that in order to remove someone who has a right to be in the property, the right party has to try and remove them. So it depends who owned the home. If dad owned the home, then whoever acquires dad's rights once he passes away is the only person who can remove that. And that might be the trustee of the trust that the home's owned in, or that might be the administrator or the executor of the estate. So, you know, you may have been in constant contact with your father, you and your brother and your sister, and then, you know, father passes away, the caregiver's still there, and you, the siblings, might ultimately have the right to that home, and you, the siblings, might ultimately have the right to the proceeds of the sale of that home if that's what you want to do, but you don't automatically get the right to manage the home upon your father's death. It has to go through the probate process. And so that's something, that's the first consideration, that the party who has managerial powers over the property is the one who has to step in. So the second thing is, what rights does the caregiver have? You know, again, it goes back to those same concepts we've been talking about. If this caregiver has been staying there in exchange for room and board, they've been providing care, they've likely acquired some tenant rights. And so that doesn't mean that, you know, they can never be removed. That doesn't mean they stay there forever. But that means that they did something in exchange for the right to be there. And so they become a tenant, and they have to be terminated through the process we talked about. Again, if anyone finds themselves or someone they're assisting in that situation, a trust and wills or probate attorney is probably the best person to turn to on that. The next question is, if someone is staying in an Airbnb and they won't leave, how does the landlord get them out? And I will confess I'm a little less familiar with the rules behind short-term rentals. It's sort of similar to how someone is a hotel guest and prior to residing in a place for a month, that person does not require tenancy rights because they're a short-term guest. After an extended period of time, that person might acquire tenant rights. And so in this case, I would, refer folks to a private real estate attorney or Airbnb's legal counsel if that's the type of folks that they've been working with, and say probably what makes the biggest difference in this case is the length of stay. Would you consider a tenant? Would you consider a handyman who lives in an RV parked on the front lawn of a property someone's tenant? And this definitely sounds like the type of situations we get in Northern California out here, because it's very clear that someone who has an RV who's parked in an RV park falls under tenant rights. I mean, they're paying for they acquire tenant rights by paying for the space. It's a little less clear than when it's not in a formalized park with a formalized rental agreement. But again, I think we're going back to those basic principles here. Does the person have the expectation to stay if they're doing something of value? So this is a handyman. He's been permitted to come in there. He's doing something of value. You might not thought he's done everything you allowed him to do, but he certainly has an expectation to stay. And again, I know this is annoying to folks sometimes, and I know that if you have a home or second home, it's something of value to you, and it's annoying that it can't just be cleared and turned over. But on the flip side, this is someone who had an expectation they could stay, and did something of value to stay, and so that entitles them to the process, which might seem slow and onerous to you, and even slower and onerous nowadays. But it certainly doesn't mean it's indefinite, and it certainly doesn't mean that asset or that property is beyond you forever. And then again, if any of these circumstances where it becomes difficult to remove someone or inconvenient to remove someone, implicates violence or implicates somebody's safety, then of course there are exceptions to these pauses. But even if you've got an RV on a property, you've been permitted to occupy that property, you're doing something in exchange for it, and so that probably gives you tenant rights, especially if that's a relationship that's been going on for a long time. So the next question is a bit of a broad one. What if the tenant or owner does not have mental capacity? So this could arise in many different situations here. Any rental agreement is a legal contract, and you can't enter into a legal contract without initially having capacity. And so if, I'm trying to think of an example of this, but if, a senior's renting out their home to somebody and they didn't have capacity to enter into the agreement in the first place, that whole contract might be void. If at any time in the proceedings someone loses capacity to continue, then legal proceedings shouldn't move forward until someone who has that capacity, such as a power of attorney, steps in. On the flip side, though, if you're assisting a dependent adult or an elder who has lost capacity and they're in the middle of an eviction, the eviction will move forward. That won't stop it, unfortunately. It might make this person eligible for some sort of equitable relief, like a pause on the eviction, that stay of execution that we talked about. But someone who is running out of their last straws there, and not understanding the entire process, that's not going to insulate them from that, unfortunately. Mental capacity would come more into play on the owner side, whether the owner had the ability to enter into this contract in the first place, and whether the owner has the ability to start a lawsuit in the first place. The next question here, what if an owner is terminating the tenancy because they are selling? And the answer to this question is broadly that is allowed. For tenancies that an owner is permitted to terminate without cause, it's irrelevant whatever reason they have, right? And so if you're one of these tenants, and so it's usually someone renting a single family home, or someone who's lived in a property for less than a year, or somebody who is living in a property that came on the rental market in the past 15 years. So all those exceptions to the new just cause protection rules. If you're someone in those exceptions, the owner doesn't have to tell you why they're terminating your tenancy, and for those tenants who do get the benefit of just cause protection, so those federally subsidized properties and multifamily homes that have been rented for about 15 years or more, removing the rental property from the market, which is sort of a precursor to sale, is a permissible reason to terminate someone's tenancy. Under the new California Just Cause Law, which you might know as AB 1482, or it's codified in Civil Code Section 1946.2, removing a rented unit from the rental market is considered a no-fault cause, which means it's the owner is allowed to terminate for that reason, right? But it's not the tenant's fault. And so one of the extra protections that those tenants get in those situations when the owner is terminating their right to be there for a no-fault reason is that the owner has to give them 1 month off on rent or refund their security deposit up front, right? It's sort of an acknowledgement that this is happening to someone, even if they've been a good tenant, and so they need a little assistance to find another place. And so that would be that's a wrinkle to this situation here. For renters in mobile home parks and RV parks, if a park is selling or is shutting down, there are special rules for relocation in those situations. So if you're assisting a senior in one of those situations and they hear the owner is selling, they actually have more rights to more relocation. And that's an acknowledgement that we call them mobile homes, but they are not mobile in any practical sense. And so the folks living in there are often older, on fixed income, and vulnerable, and so it's the laws are written to give these folks a chance to move to a safe place. Then sort of the last note is that which is a little beyond the scope of the question, but the last note I'll make is that if a sale occurs during the tenancy, then the tenancy doesn't terminate automatically. The tenant becomes the tenant of the new owner. So it's permissible to sell a property while it's still bound by a rental contract. If prior to the sale, the old owner gave the tenant a notice, that notice survives the sale, so the new owner might be able to use that to remove you. But if you have a 2-year lease and the owner sells it in year 1 of the lease, the new owner has to honor the rest of the lease or buy you out of the lease. So a tenancy survives a sale is the general concept there. The next question is, could there be an elder abuse allegation or undue influence angle in those cases where the senior has been convinced to transfer title? Sure, absolutely. This happens a lot. This is something that I know that probate or trust wills attorneys would sniff out in a minute. We often see these situations arising in family cases. Mom transfers title to sister 1, and sister 2 and brother think this is a bad idea. So again, these family matters are very, very ugly, unfortunately. But I would advise anybody on sort of any side of that to consult with a probate or trust and wills attorney. Have there been any COVID-19 related changes to long-term care facility evictions? So we're going to defer that question to the October session when the experts there will be there. So unfortunately, I don't have too much to add to that, and I apologize. We're getting toward the end here, folks. If you are given the 3-day notice in June, does that mean the owner has to give you another 3-day notice after the state of emergency is over? And so the answer to that is no. If you're given a notice and your time runs in the notice, that notice remains valid, and sort of the tenancy remains kind of in a limbo state, even if the landlord can't finish the eviction through the courts. And so it could be the case that someone gets a 3-day notice to pay rent in June and they don't pay in June, but the landlord's not able to go to court. And we're in July, we're in August, and the landlord's not accepting rent, because the moment they accept rent, they waive their first notice. They can't move forward on a notice to kick you out for not paying the rent if they take the rent from you. And so it puts you folks in a funny situation where, in order to maintain their legal rights to move forward when the courts open up, the owners have to disengage from the tenancy. And ultimately, if everybody's goal is to make all the parties whole, pay the owner as much as you can pay the owner, or catch up when you can, and keep you in the housing, then this is a perverse incentive of the rule. And there certainly are a few perverse incentives of any rules or any policy. And so if someone is given a 3-day notice in June, they shouldn't expect another 3-day notice. But even if they're protected from actual eviction and court eviction by the temporary rules of the Judicial Council, we'd encourage folks practically to work things out, right? Be open and honest with your landlord about what you can do and when you can do it. See if you can come to an agreement. And if they're absolutely shutting the door on you and they said, we gave you this notice, we want you out, we're going to get you out as soon as we can, put the money in your pocket, find a new place, and then try and work things out once you move, right? We're hoping that time is a good, time brings everybody to the bargaining table here and keeps folks housed, right? Because property owners need to be paid. They have bills to pay. They have, profits that they promised to mid-level investors and, all that stuff, right? And so we don't want to put anybody out in the dark here. And so even if you might be entitled to another technical step, if you can move forward and work something out, probably everybody's better off at the end here. So the next question is providing direct caregiving and exchange. And so I think that comes down to is someone who lives with you in exchange for caregiving services. Is that going to be, could that create a tenancy? And so I think we've talked generally that someone can move in and provide caregiving and might be a tenant. I want to clarify at this point that especially in subsidized housing, especially in voucher holders, there's a carve out for live-in aides. Someone can live in a property as in someone's IHSS or in-home supportive services caregiver, but not be a tenant and not get tenant rights. And that's, I think that's more for situations when the senior or the care recipient is also a renter. And so just because someone moves in on your voucher as your IHSS caregiver, it doesn't mean that you're renting to them, right? Or it doesn't mean that the owner of the property is renting to them. I think situations where caregiving can give rise to tenancy situations is where they're moving into the owner's property. The owner is the recipient of the care. And so again, these are all in that gray area, and it certainly depends on the exchange. So the answer is, it depends on all circumstances of this situation here. The next question is, there has been an increase in incidents of domestic violence during COVID-19. Has my office used VAWA to successfully stop evictions? Yes, not during the pandemic, but in the past or in our practice, we've used the laws that are there to protect survivors of domestic violence. And so I'll make a note. VAWA refers to the Violence Against Women Act. It's a federal law, and it only applies to federally subsidized properties. And it says many things, but with regards to renters' rights, it says that a renter can't be terminated, can't be evicted for acts that rise to or domestic violence acts, right? And so a situation would be you're renting from a HUD subsidized property and you are the victim of domestic violence. It causes a disturbance, and the HUD housing provider says, all right, well, your neighbors complained about the noise on Thursday night, so I'm kicking you out. That would be a clear violation of VAWA and shouldn't occur. All right, and so that's one tool to protect victims of domestic violence. for those housing providers that are not covered by VAWA. So these are housing providers that aren't subsidized, private housing providers. There are state law protections as well, essentially saying that an act of domestic violence can't be the grounds for an eviction. And so we've used that provision as well. Sometimes it requires documentation from the police, from the courts, from a counselor. And so folks who are survivors of domestic violence, who are facing an eviction, they often need the support to get the documentation they need to protect their housing. But it certainly is a tool to help keep people housed due to domestic violence. What sort of laws do you hope the state legislature or localities will be able to provide protections for more vulnerable tenants? What should we be advocating for? So by nature of the funding my nonprofit receives, I can't really directly lobby for anything. But what I will say is that the source of all these problems is somehow connected to the fact that there's a disconnect between the cost of housing and the prevailing wage. And so in any way that folks can advocate for more housing and more affordable housing and more supportive housing, that's the only way to relieve the pressure that makes folks live in places that are in disrepair, that make folks unable to find a new place with it when they're on a 60-day notice. And so I think even if it's not COVID related directly, the lack of affordable housing is probably sort of the number one, the lack of housing in general and affordable housing is the number one cause of housing conflicts and housing tension. If you look at some localities that have rent control and have established rent control programs, sometimes there are carve-outs and additional timelines and protections for vulnerable tenants. They get a little extra time, they get a little extra relocation. And if you're helping folks and it's hard to rehouse them and it's hard to move them in the timelines that they're given, that might be something that the state and local lawmakers might be amenable to hearing. But I think really the most effective advocacy for policies are what you're hearing from the folks across the desk from you day in and day out, and just bringing their issues and their stories and helping those stories rise up to folks who can make changes. So it's going to vary from place to place. The last question here, if tenant is current on rent and has lived in the property for 11 years, the landlord passed away and daughter has given the tenant a 45-day notice to vacate the premises. Is this legal notice? Again, this is a very specific legal situation, so I couldn't comment on it without having, gathering all the facts, right? This seems like not a hypothetical, but one person situation. I will say, as we talked about before, someone who's lived in a property for over a year is due a 60-day notice. So hopefully there's some wiggle room to work this out here with the daughter and keep people housed. All right, folks, those are all the questions we had. I appreciate everyone's patience yesterday with the sound. I appreciate all the work everybody does. I hope you're staying safe and well. And our contact information should be up on the slide in case you need to follow up with us. Again, if you follow up with me with a specific legal question, I probably can't answer it, but hopefully, I can direct you to someone who might be able to. Thank you very much for your time, everyone.